Hello, everyone, and welcome to today's webinar, Are Non-Competes Still Legal? Before we get started, I would like to go over a few items so you know how to participate in today's event. You have joined the presentation in listening only mode using your computer speaker system by default. If you would prefer to join over the telephone, just select telephone in the audio pane and the dial-in information will be displayed. You will also have the opportunity to submit text questions to today's presenters by typing your questions into the questions pane of the control panel. You may send in your questions at any time during the presentation. We will collect these and address them at the end of the presentation. Today's webinar is being recorded and you'll receive a follow-up email within 24 to 48 hours with a link to view the recording and a PDF of the presentation. Today we have three presenters from Whiteford's Labor and Employment Law Practice Group: Betsy Davis, based in Richmond, Virginia; Lisa Bronner, based in New York City; and Rafiq Garbi, based in Baltimore, Maryland. Whiteford's Labor and Employment Law Group represents and advises employers in all aspects of labor and employment law. The Labor and Employment Group handles all types of employment litigation in state and federal courts and before administrative agencies. In addition to defending employers against workplace-related claims, our Labor and Employment Group also regularly assists its clients in protecting their trade secrets and other economic interests, including non-compete agreements and other restrictive covenants. To kick off today's program, I would now like to pass the presentation over to Betsy.
Well, good morning and thank you for joining us. Let's take a quick look at our roadmap for today. We're going to begin the program by talking about developments in the federal law, which is a little bit unusual for non-compete issues. Our federal agencies, as you probably have heard, have been active on this issue. We're going to share with you information about the Federal Trade Commission and the National Labor Relations Board. Next, we're going to move over to the state law. Currently, non-compete business and litigation issues are shaped generally by state law. As you will hear today, the state laws are ever changing, and it's really important that employers stay up to date on those changes. So we're going to run through with you a number of states in which we have offices and in which our lawyers practice, and that would include Maryland, DC, New York, Virginia, Delaware, Pennsylvania, California, and Kentucky. And then we're going to wrap up the program by sharing some takeaways, some practical tips, things you can do today to start protecting your company's business, customer base, interests, and goodwill. And then at the end, we'll take some questions from the chat. So we have a lot to cover. We're going to try to reserve some time for that. So let's dive right in and talk about the Federal Trade Commission. So you've probably heard, well, we'll start with this. The big takeaway today is there is not a federal ban on non-competes. And I will say that, and I will say yet. You've probably heard on the news that the Federal Trade Commission is proposing a rule to ban non-competes. And that would take effect in every state if the rule were issued. On January 5th of 2023, the FTC proposed a new rule. The vote on that rule has been delayed. We've had a lot of delays. We've been talking about this since 2020. It's anticipated that the vote will be in April of 2024. So stay tuned and we'll update you on where we are on that. But let me tell you a little bit about what the proposed rule would mean. The proposed rule is very broad. It would prohibit employers from imposing non-competes on workers, including independent contractors and unpaid workers. And the ban would extend to all contract provisions that create a de facto non-compete clause. So that means that other contract clauses that might have the effect of prohibiting workers from seeking or accepting employment would also be banned by this proposed rule. So let me give you an example of that. For example, if there's an NDA and it has the effect of limiting the worker's mobility or ability to get another job, it would also be banned under this proposed FTC rule. The other thing that's really important for employers and planning is that the rule would be retroactive. So that means that it would be, if it were enacted in its current form, not only would pre-existing non-compete agreements become unenforceable, but the rule would also require that employers proactively rescind those non-competes and tell individual employees and former employees that they no longer apply. So let's move to the next slide and I'll give you a little bit more information on the FTC. There are very few exceptions under this ban, proposed ban. The FTC would not ban narrowly tailored customer non-solicitation provisions, employee non-solicitation provisions, and confidentiality agreements. So employers, if this rule were to take effect, would have to reimagine how they're going to protect their trade secrets and customer information and confidential information, and those would be the tools to do it. So long as these agreements are properly drafted and don't become that de facto non-compete, they wouldn't be impacted by the rule. So the proposed rule would apply to and ban non-competes as part of a merger or acquisition as well. There is one exception to that rule. So for employees who are holding 25% or more of the company, so typically that's high-level executives, they may be subject to a non-compete. So that's the one exception to this very broad ban. So as I said, we're looking to April of 2024 to see what happens. The FTC is currently fielding 27,000 comments on the rule, and there is a large public and private opposition to the rule. So there's much more to come here. So now I'd like to turn the program over to Rafiq, who's going to talk about the other federal agency, the National Labor Relations Board.
Yeah, thank you, Betsy, and thank you everybody for joining us this morning. As Betsy said, historically, non-competes have been controlled at the state level, and we're starting to see different federal agencies weigh in. Betsy just talked about the FTC. I'm going to talk about the National Labor Relations Board, or the NLRB. Many of you know that the board is sort of a partisan driven entity that might flip-flop on its policies depending on who the president is. And in May of 2023, we sort of saw the board trying to flex its powers and expand the scope of its enforcement with its general counsel memo, essentially advising that non-competes have a chilling effect on workers. And that chilling effect is really the touchstone for a lot of the NLRB's enforcement actions. So as you can see on the screen, there are a number of factors that the board's general counsel cited as the reasons for the board having this authority to limit overbroad non-competes and say that these have a negative effect or a chilling effect on workers. Now, the flip-flopping, if you will, of the board's policies sometimes leads to employers saying, well, that's going to change. We don't really need to pay much attention to this. But the takeaway here is that we're already seeing enforcement efforts to go after overbroad non-competes. So it's not really a wait-and-see situation where, if there's a change, this might go away. There are very real practical effects that are going on right now. And as far as takeaways for what those enforcement actions can educate us on, and educate employers, it's hard to say right now because a number of enforcement actions have settled, and some of them are still ongoing where there's been pushback. One of the pushbacks is, as you can imagine, that the board just simply doesn't have the authority or the enforcement authority to interpret the National Labor Relations Act in this way. So there's a very fundamental pushback to the NLRB expanding its scope of enforcement to include non-compete actions. Non-competes aren't the only target of the board. This year, they've also issued rulings and memos on non-disparagement and confidentiality agreements. So there really is a trend of expanding the enforcement to cover what a lot of employers see as very typical agreements. So it's important to revisit these agreements in light of the NLRB's recent memos and enforcement actions. So as Betsy mentioned, we're just talking about some of the federal level, takes on non-competes. But now I want to shift into what historically has been the level that would vary and control non-competes from state to state. So the first state we're going to look at is Maryland, one of the jurisdictions in which I practice. And for decades, Maryland law as it relates to non-competes was really crafted by case law and court interpretation of various non-compete agreements. And only recently in 2019 did the state enact a law prohibiting non-competes. Now, the question of today is, are non-competes still legal? And for Maryland, yes, but it's not legal for certain workers. And the takeaway here is starting January 1st of 2024, the non-compete ban is going to be tied to basically a mathematical calculation. 150% of the state minimum wage, which will be $15 an hour, is going to amount to $22.50. And that's what the law says is the threshold for what we can call low wage earners. So essentially, Maryland law is that if you're a low wage earner making, as of January 1st, $22.50 and below, we're going to codify our public policy to say we don't think those non-competes should be enforceable, and they're not going to be enforceable under law. One of the practical takeaways is that there aren't really any safeguards in place or any penalties in place for an employer to have an employee enter into those agreements. So if you want to take it to its ultimate resolution, it may still have to go before a judge or through the court system to figure out whether that non-compete is enforceable or not, notwithstanding the law that sets that threshold. So, we have a threshold for low wage earners, and as we shift into our next state or jurisdiction in this instance, the District of Columbia also very recently enacted a law prohibiting non-competes. And as opposed to the Maryland law, it is much more broad, much more robust. The main takeaway for the DC ban on non-competes is that there is a highly compensated employee threshold that right now is at $150,000 a year. Now, there are other exceptions, so it's important, depending on what kind of employer you are and what kind of employees you have, to explore whether there are those exceptions. But if we go to the next slide, you can see some of those exceptions, and keep in mind that there are a number of them. But if you go to the next slide, that highly compensated employee threshold really covers a lot of folks. And so if you're just boiling it down, if somebody makes less than $150,000, chances are in DC they're not going to be allowed to enter into a non-compete, and of course they are going to see that as non-enforceable. As far as other important exceptions, there's a medical specialist exception, and that threshold is $250,000. So another important takeaway here, between the two exceptions, $150,000 for highly compensated employees and medical specialist employees, there is another cap that you have to keep in mind. For highly compensated employees, $150K and above, even though you can have them enter a non-compete, the law limits it to 1 year in duration. And then for medical specialists, it's limited to 2 years in duration. So even though a worker might make well in excess of the threshold, there are those caps, and it's not carte blanche to have them enter into whatever duration of non-compete that you see as reasonable. So important to revisit any non-compete agreements and see if they're compliant. One of the important things to note in the DC non-compete law is that it also affects the ability of current workers to engage in secondary employment or moonlighting. A lot of folks just think of non-competes as, oh, this is what happens when an employee leaves, and this is what we limit them to. In DC, there are provisions in the non-compete law that speak to secondary employment or concurrent employment and it's important to have conflict of interest policies that meet the criteria there, so that you're not missing out on some of the provisions there that might limit your ability to keep somebody from competing even while they're working for you. So again, just looking back between two jurisdictions that neighbor each other, Maryland and DC, you can see the wage earning threshold vary greatly from the $22.50 an hour, which annually shakes out to about $41,000 a year, to right across the way in DC, having the threshold be at $150K. So there's a wide amount of difference between the different states and jurisdictions, something you'll see here. And I think I'm going to turn it over back to Betsy, I believe, for the rounding out the DMV with Virginia. Oh,
We're actually going to.
Actually, Lisa with New York. My apologies.
Hello. Yes, so I'm going to speak to New York. There's plenty of case law in New York about non-competes. New York courts generally disfavor non-competes and enforce them when certain conditions are met, where it's necessary to protect the employer's legitimate business interest. It doesn't impose an undue hardship on the employee, doesn't harm the public, and is reasonable in the time period and the duration of the non-compete and the geographic scope of it. Next slide, please. As many of you may have heard in the news, since New York is such an economic hub to the nation, there have been a lot of eyes on New York, and a bill that passed in the New York legislature back in June of 2023. People have been waiting with bated breath to see what the governor would do, because this bill, which passed in June, would essentially ban all non-compete agreements and certain restrictive covenants. It would amend New York's labor law to add a new section, 191D. Significantly and very interestingly, it would apply not only to employees, but what the statute calls covered individuals, which would mean people who perform services and have some type of economic dependence. So it could include independent contractors, although the term independent contractors is not explicitly used as a term in the statute. It seems to be broad enough to encompass independent contractors, which is a category really we haven't seen with some of the other statutes we've been talking about. Employees would have employees and independent contractors, or those performing services, would have a private right of action in court. They would have 2 years to bring a claim, which would begin. The 2 years would be within 2 years of the later of one of a few things: either the date the non-compete agreement was signed, the date that the covered individual learned about the non-compete, the date that the employment or contract is terminated, or the date that the employer takes any steps to enforce the non-compete. And another aspect of this bill that passed is that it would seem to encompass, because it does not exclude, a banning of non-competes in the context of a sale or merger of a business, which is something that not even California, which is known to be very pro-employee, not even California would prohibit non-competes in the context of a sale or merger of a business. Even the FTC's proposed rule would not prohibit non-compete agreements in the context of a sale or merger of the business. Next slide, please. What this bill would not affect, it would not affect employment agreements for a fixed term. It would not prohibit agreements that protect trade secrets, confidential and proprietary information, but so long as these agreements do not otherwise restrict competition. It would also, the bill would not prohibit non-solicitation provision relating to solicitation of clients who the employee learned about during employment. Again, so long as the provision doesn't otherwise restrict competition. Next slide, please. The remedies under the law, as I mentioned, there is a private right of action. The court may void the non-compete agreement and order all appropriate relief, including injunctive relief, liquidated damages up to $10,000, lost compensation damages, reasonable attorney's fees and costs. What's significant or notable also in this bill is that it says the court shall award liquidated damages. So it indicates essentially that liquidated damages would be a mandatory award, which is also something that seems to be highly unusual. New York labor law, section 202K, currently bans non-compete agreements for certain broadcast industry employees, and that would not change, this law would not change that provision. Next slide, please. So just to give you a sense really more about what the actual language is in this bill, it would prohibit employers, their agents, or other entities from seeking, requiring, demanding, or even accepting a non-compete agreement from an employee, independent contractor, or any other person, actually any other person who, whether or not employed under a contract of employment, performs work or services for another person on such terms and conditions that they are in relation to that other person in a position of economic dependence on or under an obligation to perform duties for that other person. The agreement, a non-compete agreement, any agreement or clause in the agreement between an employer or covered individual that prohibits or restricts the covered individual from obtaining employment after the conclusion of employment with the employer included as a party to the agreement. Any contract provision restraining an individual from engaging in a lawful profession, trade, or business of any kind would be void under the bill. Next slide, please. So you may have also heard that the governor, who has not yet officially received the bill, has spoken to reporters to indicate that she will not be signing a bill that this bill in this current form. So New York will not see a full ban on non-competes. However, she indicated that she would support a law that bans non-competes for low and middle wage workers. She suggested that she might allow non-compete agreements for those earning at least $250,000. So she suggested that she would seek changes to this bill, which is Senate Bill 3100. She has until December 31st to sign or veto the bill. She has 10 days after she receives the bill, which she has not received, to sign it or veto it. So it's possible she may sign the bill and request a chapter amendment with those changes that she's seeking. By way of background, she had already indicated in 2022 that she would support a bill that banned non-compete agreements for low and mid-wage workers. And I should just clarify that, again, that covered individual under the bill that has been passed does not specifically specify independent contractor. It does speak more broadly to any person who, whether or not they are employed under a contract, performs work or services for another person under terms and conditions that they are in relation to that other person in a position of economic dependence on and under an obligation to perform duties for that person. So it is just, the covered individual definition is broader than simply an employee. I did want to address, next slide, please, unless we're, okay, we could go back. We're gonna just stay in New York for one more moment, because you may have some questions, because there are some open questions about this bill that remain unanswered. And so we don't have the New York State Department of Labor under this bill that could provide guidance. It's really gonna be up to the governor to, to indicate what modifications there would be. The bill, for instance, does not specifically address the validity of employee non-solicitation agreements. So, for instance, whether employers will be able to prohibit an employee who's leaving from soliciting other coworkers to come work with them. There's a possibility that even though the bill does address non-solicitation of clients, those agreements could be permissible. There could be a situation where where you have a provision, non-solicitation provision for an employer in a small industry that has few clients, and that non-compete bill might result in invalidating a non-solicitation provision. Because remember, the bill says, even though it has some carve-outs, so long as those provisions do not otherwise restrain trade in some way. And as I mentioned, I think a real sticking point of this bill is that it does not specifically carve out or exclude non-competes in connection with the sale or merger of a business, which is something, as I mentioned, that we've seen both with California and other legislation, and even the FTC's proposed rule. So that seems to be a carve out that would need to be part of any type of final bill. One last thing I would mention is that I think objections by the business industry are really that the bill that was passed in New York doesn't reflect relationships in the marketplace, the nature of goodwill with customers, and doesn't capture the careful balancing of interests in this area that New York courts have already been developing. And there's a concern in New York, which, as I mentioned, is such an economic hub for the nation, that in a state where many employers are already fleeing New York because of the cost of doing business here and regulations, that a law banning non-competes would only intensify and hasten the departure of many employers and businesses in New York. So, and with that, I turn it over to my colleague to address Virginia. Betsy.
Great, thank you. So I'm going to address Virginia, Delaware, and Pennsylvania, and we'll start with Virginia. The answer to the question that we're all asking today in each of these different states is that yes, non-competes are enforceable in Virginia, but they have to be narrowly tailored to protect the employer's legitimate business interests. And our courts will look at generally 3 factors to determine that. They'll look at the geographic scope, they'll look at the temporal period, and they'll look at the scope of the restriction. And so the scope of that restriction really does have to be limited to the same or a similar position that the employee has with the company. We all know that these are very difficult to draft. They're difficult to draft because you're drafting them today, and then you're going to, if you have to, attempt to enforce them years from now. So as we've been saying throughout the presentation, it's always a good idea to review, and the laws are changing, it's always a good idea to review these provisions, annually or every other year, and make sure that they're drafted in a way that's going to grow with the company and with the employee. So, in this interim period between the time when the agreement is executed and you might have to enforce it, the employee's job may change. If they are in sales or have a territory, that territory may change. The business of the company may change. So you really have to make the agreement flexible and narrow, which is a hard thing to do. Virginia for a long time had no statute related to non-competes. We now have a statute, and it is along the lines of what you're hearing in other states. It's a low wage earner statute. And so the key really is, how do you define a low wage earner? So in Virginia, employers are prohibited from requiring that low wage earners enter into non-competes or enforcing ones that have already been entered into. of course, you have to be a mathematician to figure out any of these calculations. They can't just give you a number. It has to be something that you have to check every 3 weeks with the Department of Labor and the Virginia Employment Commission. So in Virginia, a low wage earner is someone who's earning less than the average weekly earning of the average weekly wage in Virginia. So who knows what that means? Let me tell you what it means today. It might change tomorrow, and it'll certainly change in a year. Currently, that number is $1,343 per week. If someone makes less than that per week, they're a low wage earner, and you cannot require that they enter into a non-compete, and you cannot enforce a non-compete. That equates to about $69,836 a year. So you heard Rafiq talk about that low wage earner number in DC is much higher, in Maryland is much lower. So Virginia's in the middle there. And the rationale really is that, if you have someone who doesn't have access to confidential information, maybe a line worker or someone in, food services, if they don't have the secret sauce, they don't need a non-compete. And so that's where the low wage earner definition is really targeted. Just like we heard from Lisa in New York, this statute isn't really focused on that definition of employee that we look at for other legal issues. It includes interns, it includes students, it includes apprentices, independent contractors who are compensated at an hourly rate less than the median hourly wage in Virginia. So we have to be looking at all of that. The statute does exclude employees who predominantly earn their wages from commissions or incentives or bonuses. So the typical example there is a salesperson. That person can be subject to a non-compete. So let's move on to the next slide. Another issue that we see when we're trying to enforce non-competes or decide whether it's worth pursuing is this issue of blue penciling. So blue penciling, a little bit of background, is the concept of a court basically rewriting or editing in some way a restriction that may be overbroad so that it can be narrow enough to be enforced and enforcing it. Virginia does not do that. Virginia will not blue pencil. An example of a blue pencil would be a geographic scope of 4 years that doesn't make sense in the context of the employee we're talking about, and the court saying, okay, I'll enforce it, but I'll only enforce it for a year. In Virginia, because the court doesn't blue pencil, the court will say it's overbroad and the entire non-compete is unenforceable. So whether or not a state blue pencils really impacts how an employer is going to draft that non-compete and whether the employer is going to prevail in enforcing it. And we'll talk about that with respect to some other states. So let's move on to Delaware. So everyone knows that Delaware is a common state of incorporation. It's very pro-business. And so many clients will have or want to have Delaware as a choice of law provision for non-competes. And the factors that courts in Delaware look at to determine whether or not a non-compete is enforceable is similar to other states, similar to Virginia. The court wants to see a reasonable geographic scope and a reasonable time period. And then we'll look at factors related to the industry. These are very case-specific analysis. And in Delaware, generally 1 or 2 years would be reasonable for a restriction, again, depending on the facts and circumstances around that particular employee. And Delaware traditionally has been willing to blue pencil. So many times the strategy of employers has been, if they're incorporated in Delaware and Delaware has a strong public policy related to fair competition, they would want their restrictive covenants to be governed under Delaware law. In 2023, we've seen a little bit of shift in Delaware to a higher level of scrutiny on these restrictive covenants. And as we talk about all these states and the new legislation and the federal agencies, becoming involved in the issue, you see the trend throughout. So there are recent court cases in Delaware where the court is looking very carefully at whether it's going to enforce a choice of law provision which would allow Delaware law to apply to these restrictive covenants. Courts have recently elected not to blue pencil, even though it is available to them. So they're finding the restrictions are overbroad and not enforcing them. So Delaware once was a very friendly state for restrictive covenants, and there seems to be a shift, particularly in 2003. So let's move on now to Pennsylvania, talk about that a little bit. Again, the question, are non-competes enforceable and legal? Yes, in Pennsylvania they are, but again, they have to be appropriately drafted. When I talk with clients about how to draft these restrictive covenants, I like to say, let's capture the whale and let the minnows go. Sometimes, folks want to get every little detail, prevent their now former employee from, taking any kind of competitive action. And that is where we often get in trouble. And it happens in all of these states. Pennsylvania courts, like we've seen in these other states, want to follow similar factors about enforceability. They want to make sure there's adequate consideration for the restrictive covenant. Again, they want a limited geographic area and they want a limited time. And then they want to make sure there is that nexus to protect the employer's legitimate business interests. So, your typical salesperson is a great example. Employers are spending, their money having these employees meet with customers, build relationships, and it takes time to build that relationship and get the sale. And then move to another employer and benefit from that relationship, that would be a type of unfair competition. So that's why these provisions are appropriate in some circumstances and not in others. Unlike Virginia, Pennsylvania will blue pencil. So as we've seen in other states, there's one more thing to talk about with respect to Pennsylvania and a little bit of a shift. So again, in 2023, it seems to be the year of changes in non-competes. On March 15th, state senators introduced a bill. It's a Healthcare Practitioner Non-Compete Act, which if enacted, would render the healthcare non-compete agreement unenforceable in Pennsylvania for all practitioners and groups. But there's a catch. The act only applies if the healthcare practitioner is dismissed. And then there's another catch. They don't define the term dismissed in the act. So a lot of this legislation is changing. There are a lot of open questions. They haven't been litigated yet. I expect that there will be a lot of litigation over the issue of what it means to be dismissed, whether that includes someone who's fired for cause, whether that includes someone who's fired without cause, or somebody who's constructively terminated. In other words, they complain and complain and complain, and the atmosphere is just so toxic that they have to quit. So it remains to be seen whether these scenarios would constitute dismissed under the statute. And so we'll have to wait and see on that. But as you can see, all of these states are selecting issues, whether it's a low wage earner issue, whether it is a particular industry or job category, and they're starting to submit and pass legislation that's addressing these non-compete issues. So as I said at the beginning, these things are changing monthly. We have to keep up with them. Many of the bills that are being passed, some of them are retroactive, some of them become active immediately. And so it's really important to stay up to date on this. So now I'm going to turn the program over to Lisa, and she's going to talk about everybody's favorite state with respect to non-competes, California.
Yes, thank you. So thanks, Betsy. As you may already know, employee non-compete agreements are void and unenforceable in California. There's a very limited exception as I'd mentioned in an earlier slide, about for sales and dissolutions of certain businesses. So California's Business and Professions Code, section 16600, currently voids contracts that restrain an employee from engaging in a lawful profession, trade, or business of any kind. State courts have historically applied this section to bar agreements made in California restricting post-employment competition with limited exceptions. Next slide, please. So why am I talking about California? Because California, interestingly, has a new law that's taking effect January 1st, 2024. It was signed into law in September of this year. There's a new section that will be added to the California Business and Professions Code 16600.5, under which any contract that is void under the law is unenforceable regardless of where and when the contract is signed. So this is very significant because California is taking the position that it's public policy against the restraint of trade, against the restraints in entering into a profession, trumps other state laws when an employee is seeking employment in California, even if that employee signed a valid non-compete agreement in another state. So they live in a state where non-competes are lawful, they move to California, and California is saying that non-compete agreement, even though it was lawful in the state that this employee entered into it, is now unenforceable in California. So the law also that prohibits employers and former employers from attempting to enforce such a non-compete agreement. That agreement is considered void under California law, regardless of whether it was signed in, regardless of where it was signed. Next slide. And also, you may have a situation with a remote employee who is working from one state but is working for a California employer, and any non-compete that they signed in another state, California would deem to be void and unenforceable. So the legal remedies under this new law, an employee, former employee, or even a prospective employee may bring an action for injunctive relief, recovery of actual damages, reasonable attorney's fees and costs against the employer who is not a California employer. It's also considered a civil violation for an employer to enter into or to seek to enforce what California deems to be an unlawful non-competition agreement. Again, even if that non-compete agreement was lawful in the state in which it was originally entered into. And as I mentioned earlier, California does have a narrow exception to its ban on non-competes, which is the sale or dissolution of a corporation, partnership, or limited liability company. Next slide, please. In addition to the new law that I just mentioned, California has also signed into, or the governor has signed into law, AB 1076, which is also, it codifies existing case law that explains that any non-compete in an employment context, no matter how narrowly tailored, is void. And that this law, AB 1076, further clarifies that California's invalidation of non-compete agreements is not limited to contracts where the person is a party to the contract. So that's really, getting to non-poach agreements. So this is a significant change. It also, AB 1076, the intention is that the law regarding non-competes And section 16600 is meant to be read broadly. So that's one of the other purposes of AB 1076 is to make clear that the courts are to read the law broadly and to avoid the application of any non-compete agreement in an employment context or any non-compete clause in an employment contract, no matter how narrowly tailored. The other really significant thing about AB 1076 is that there is now a notification requirement under the law. Specifically, employers must notify their current employees and even former employees who were employed on or after January 1st, 2022, where the contract includes a non-compete provision, or who were required to enter into a non-compete agreement where it doesn't meet the narrow exception that I mentioned. They need to notify, these employers have to notify those employees and former employees by February 14th, 2024, that the non-compete clause or non-compete agreement is void. So they have to provide a written notification. The employers have to provide that in a written individualized communication delivered to the last known address and email address of the employee or former employee. And a violation of this law, which would include the failure to provide this notification, constitutes an act of unfair competition, and employers may face a civil penalty of up to $2,500 per violation. Next slide, please. Okay, so moving on from California, Kentucky, just to kind of give an overview, much like some of the other states that we talked about, enforces non-compete agreements if they're reasonable and supported by consideration. Consideration means something that an employer is giving to an employee. It has to be more than just I'm continuing to employ you and therefore I can enforce my non-compete. It has to be something more than that in exchange for the employee's agreement not to compete. And again, as with New York and other states, some other states, there's a requirement that the courts have looked at that the non-compete is reasonable both in terms of the time frame, the duration, and the geographic scope. Like some of the other states that Betsy had spoken about that allow blue penciling, courts to blue pencil, meaning that they can look at a non-compete agreement and decide that it's overbroad, but as a court, they're going to narrow the scope of the restriction. Courts in Kentucky have the authority to blue pencil overbroad non-competes to narrow the scope, and the courts will analyze whether a non-compete is enforceable on a case-by-case basis. Next. So just some legislation to point out in Kentucky, just as in, it sounds like other states that have focused on the healthcare industry in particular. Kentucky in March of this year enacted a law amending a prior law in 2022. And what this law in March did was it removed a ban on non-competes that had existed for permanent direct healthcare staff. So that means that permanent healthcare staff, employers can impose non-competes with respect to those, that category of worker. However, the law clarified that the non-compete ban applies only to temporary healthcare staff. So there cannot be non-competes with temporary healthcare staff, but there can be for permanent direct healthcare staff. And that was the change that was made. There's also a law that was passed in 2022 in Kentucky relating to PEOs, professional employer organizations, essentially saying that they can't modify or amend any contractual relationship or restrictive covenant between a client of the PEO and an employee, so that they essentially can't interfere with those types of agreements that are entered into between the employer and employee. Next slide, please. And finally, to just kind of wrap up on a number of the things that were said by Rafiq and Betsy and myself, some takeaways for you are review the agreements that you have as an employer. If you have non-compete agreements, non-solicitation agreements, or offer letters or other documents that may contain restrictive covenants like non-competes and non-solicitation agreements. It's a good idea to take a look at those for, well, I guess we're going to wait and see what happens in New York. If the bill passes, even with chapter amendments that would encompass independent contractors, we're going to have to wait and see what happens. But it would be good for you to, in any event, to take a look at your agreements and see whether you do have restrictive covenants with independent contractors and how broad those may be. Review and update your confidentiality agreements, any agreements that you have to protect your trade secrets to ensure that they're going to be enforceable, and take a look at any policies you may have on trade secrets, confidential information, the use of organization materials, codes of conduct. Consider what training you're doing already for your new hires on protecting confidential information and also ensuring that they're not bringing trade secrets from their prior employer. So take a look at what training you're doing to let new hires know of what your policies are. For those with employees who are in California or moving to California, remain vigilant regarding the notice requirements. And then, of course, confer with your attorneys and stay abreast of proposed legislation, including the things that we've talked about today, by subscribing to our client alerts, where we are monitoring these, and we'll continue to let you know as we become aware of changes and developments.
Thank you, Betsy, Lisa, and Rafik, and thank you everyone for attending today's webinar, Are Non-Competes Still Legal? As previously mentioned, you will also receive a follow-up email within 24 to 48 hours with a link to view a recording of today's webinar, as well as a PDF of the presentation. On behalf of Whiteford and our presenters, thank you for joining us, and stay well.
Thank you.
Thank you.